Next slide, please. Today I will discuss shortly about the regulatory frameworks in South Korea. South Korea is notorious for having a harsh regulation for investment and especially for foreign companies. However, regarding crypto assets, there actually has been a little amount of regulatory works here, although the local exchanges who dealing with fiat currencies are having a hard time dealing with the bank, which I will discuss shortly after. Next slide, please. So today I will be talking about three topics because related acts in Korea are actually, I think, are three. The first one is about AML. This is the only law currently stating about virtual currencies or virtual assets. We call this acts on reporting and using specified financial transaction information. So this is the AML Act of Korea. The second act is the Financial Investment Services and Capital Markets Act. This is basically similar to the Securities Act in the US and deals with securities. Now, this law doesn't specifically mentions about virtual assets, but their interpretations. And recently they came out a STO guideline regarding this law, so that I will cover also. Thirdly, this is a new law which has not been enacted yet. It is called the Act on the Protection of Users of Virtual Assets, etc. So this will be kind of a general law for virtual assets. That is not a security, which I will also, of course, cover. Next slide, please. So under AML law, we call it AML Act of Korea. This is the only law that defines virtual asset in Korea. However, the main focus of this law is about regulating money laundering activities. So like many jurisdictions, we do follow the guidelines by the FATF. And this is the law to cover that area. Next slide, please. So the definition of virtual asset is in here. It's very broad. It's defined as electronic representation that has economic value and can be traded or transferred electronically, including any rights therein. So the virtual asset definition of virtual asset is very broad, in my opinion. However, we usually cover cryptocurrencies with this. Now, we do have a definition for VASPs, the virtual asset service providers. It is would be any of the six activities. It can be covering not only one, but maybe all of the six as well. Next slide, please. However, in practice, the KOFIU, which is the main body regulating the AML activities in Korea, categorizes VASP as three categories in practical sense. So they have exchanges and custodial services and wallet services. So if you apply for VASP in Korea, they will ask whichever of three would you fall under. Now, if you want to act as a VASP, have a business as a VASP, you need to obtain license. However, it's a bit different, in my opinion, than other jurisdictions where you will have to have a prerequisite on the ISMS certificate. This is a information security management system kind of a certificate similar to that of ISO in global sense. You need to obtain this before applying for any licenses. Now, this is more of a hardware issues that your company has to get before the licenses. And if you want to deal with fiat currencies or cash, if you say, a special arrangement with local bank is also a prerequisite. Now, this is very difficult, actually. The law is very simple on this. However, the bank is very picky on choosing which exchange that they want to work with. So there are only 5 major exchanges in Korea who has made an agreement with bank, and as some of you may know, Binance is trying to get into Korea, and how they're going to come in is that they want to acquire one of the major exchanges called KOPEX, which has actually a deal with the bank on this issue. So if Binance comes to Korea, they want to have an exchange that can deal with fiat currencies. Next slide, please. I don't think I have much of time, so I will go quick on the rest of the slides. But the next law that I want to talk about is the Capital Markets Act. This is the Securities Act of Korea. Now, the interesting thing is that this doesn't talk anything about cryptocurrencies. However, recently they came out a STO guideline. So this guideline provides certain criteria for a digital token to be categorized as investment contract securities. Now, investment contract is not the same as that of the US, because in Korea we have a certain criteria to be regarded as securities, which is different from how we test. However, it's pretty much similar in the details. So the guideline will provide how a token will be regarded as security, and how the government will draft a new law on the security token transfer market. Next slide, please. So how do you define how do you categorize a token as security? The guideline gives us some examples or some criteria on the tokens. So if a token represents as an equity interest in the operation of a business, or if it has a dividend rights, or it has some claim of the assets, or let's say the issuer attributes profits to the investor based on the performance of the businesses, or the payments to the investor constitutes a distribution of his profits. These are the examples of criteria that will be that a token would be regarded as security. However, this is not a law. This is just the criteria that the government has provided as an example. They say that they will look at the criteria on a comprehensive basis, on a case-by-case basis. So that interpretation is quite open and vague. And the government is actually saying that it is the responsibility of the issuer on whether the token will fall under the category of security. Next slide, please. So this is actually, I think, it's more important because this is where the token is unlikely to be considered as security. So if it's just a form of payment, then it's not a security. If it has no promise of redemption, or it goes on, then this is actually the first time when the government has said that this is all the examples of where the token will not be regarded as security. Next slide, please. Regarding security tokens, the government is saying that it will be regarded as a security, but it's like electronic security. So we do have a specific law on this. On electronic securities, where you deal with where you deal with electrified securities and not those that have a physical presence. So the FSC, the government, is saying that they will amend the existing law to get this electronic securities for the tokens. They say that the alternative trading system for security tokens will be allowed. However, that will require the amendment of the law as well. Next slide, please. The interesting thing about this ATS and the issuance of the security token is that the government does not like the crypto assets to be involved in the security token platform. So if you're using DLT, the distributed ledger technology for such security tokens, it should not use virtual assets. So this should be segregated, and ATS, the trading platform, cannot list its own token. So this is different from the approach from other jurisdiction in Korea. The Korean government is very hesitant of letting the traditional token cryptocurrencies to mixed with security tokens at this point. Next slide, please. So let me just quickly touch on this. This is a new law to be enacted within this year. This is called the Act on the Protection of Users of Virtual Assets. This will be the general law for non-security tokens. So its main focus would be on consumer protections, those who are trading within exchanges. So this is, at this point, this basically regulates the activity of the exchanges and the tradings thereon. We don't have any law regarding ICOs in Korea right now. So regarding ICOs, this will currently Korea has no regulations on that. Can you go next slide, please? So this is the details of the law. However, for the sake of time, I will end the slide here. If you have any questions, please let me know. Okay, thank you very much.
I think the protection of users of virtual asset legislation. Yep.
Okay, great. So as you know, we have a very big issue on Terra and Luna tokens. Although I think that is more of a global issue, that the Koreans are very are interested on regulating and preventing such activities. And that's why this law has come out very quickly. The legislation was the both ruling party and the opposing party was had no concerns on passing this law. So this governs on the activities within the exchange. I know that many foreign investment companies do have stake in the Korean exchanges because we have a large amount of dealing within the Korean exchanges. But this law now will have some power to grant the power to the FSC, the Financial Service Commission in Korea, to conduct any supervisory inspections to see if there are any illegal activities on the trading area. So the definition of illegal activities is vague at this point. We are still waiting for the presidential decree, which will detail the activity of the definition on the law. However, before this law, there was actually no regulation on the activities of any traders within the exchange. However, after this law, there will certainly be some kind of boundaries where the traders can act. The details have to come on the later period, but it will come within a few months. So we will keep you updated on that as well.